On the 31st of August 1990, a bank security vehicle is making its way to a hospital in Johannesburg to deliver wages to the staff there. To ensure the money is safely delivered, 2 armed policemen accompany the bank van in a separate car. All of a sudden, the 2 vehicles are surrounded by a gang of men carrying AK-47 rifles. The men open fire. 2 people in the bank vehicle are killed and 1 is seriously injured. Both police officers are also killed. Themba Makwanyane and Mvuso Mchunu, 2 members of the gang, are arrested, tried and convicted for 4 counts of murder, 1 count of attempted murder, as well as a count of attempted robbery. They are sentenced to death on each of the 4 counts of murder. I'm Cecelia and this is Landmark Judgements, a show about South Africa's major constitutional court cases. This series is brought to you by the Friedrich Naumann Foundation for Freedom. This episode is about the Constitutional Court's very first case, S versus Makwanyane and another. It deals with the constitutionality of the death penalty. I sat down with senior counsel Gilbert who acted for the applicants, Makwanyane and Mchunu. How did this particular case come before the Constitutional Court?
For those who were interested in constitutional law, as I most certainly was, and who were so excited about the advent of the Constitution and an entrenched Bill of Rights and courts which had the testing power, we were very aware of the big constitutional cases around the world. And we certainly knew that one of the earliest and biggest cases was going to be the death penalty. It was a question which was ducked at the constitutional negotiations because it was a hotly contested issue. And those who drafted the Constitution chose to be silent about it. So, and that too was well known. So it made sense, as it were, to keep an eye out for the first case in which there was going to be an appeal against the death sentence. And one of the best legal journalists in this country, Carmel Rickard, phoned me about it. And I said, well, the easiest way to find out is to speak to the registrar of the Court of Appeal in Bloemfontein and to find out which, if any, death penalty appeals are going to take place after the 27th of April 1994. And there were a number of them that had been set down for appeal in the Supreme Court of Appeal. And she was anxious to know whether any of those cases were going to raise the constitutionality of the death sentence. And I know that she spoke to several of the counsel who were in those various cases which were coming up. And she phoned me with some anxiety to tell me that she had spoken to one of the pro Deo advocates and asked him whether he was going to raise the Constitution, to which the answer was, what Constitution? I then relayed that to Wim Trengove, who was a close friend of mine and an equally enthusiastic constitutional lawyer. And we approached the Bar Council, and they mandated Wim and me and Jeff Budlander of the Legal Resources Centre to do that appeal. And it so happened that that was the Makwanyane case. And that's how it came to the Constitutional Court. It was one of the first of the death sentence appeals, and up until that point there had been a moratorium on the actual implementation of the death sentence, and this was the case which was going to test its constitutionality.
I also sat down with senior counsel Wim Trengove, who acted for the applicants together with Gilbert. He was the very first advocate to appear before South Africa's brand new Constitutional Court.
Everybody was very anxious, very tense, very excited, and very determined to make a good showing, because this was our first run. It was a spectacular case because it was new law, new judges, new court, new everything, and there was no precedent to draw on, you know. The case was brought as the first case before this new court. The court asked the Bar Council to arrange an advocate to appear for the accused, Makwanyane. And the Bar Council asked me and others, Gilbert, Marcus and others, to appear for them. So we were there on the day. I think advocates and judges and everybody equally nervous because it was such a spectacular event. You know, we had just launched the Rainbow Nation, the new democracy, Nelson Mandela, and all of the spectacular things that went with it. And this was one of the features of this new society. But also to make a case and an argument without any existing jurisprudence was also quite daunting. We put in a lot of work in researching the issue worldwide. And I had a look at our heads of argument the other day. I'm actually quite proud of the fact that we put together quite a respectable argument from scratch. We certainly put in a lot of effort. And on the day, it was, I was the first to argue. So I was the first advocate ever to argue in our constitutional court before this new court and the new judges and the new everything. And it was spectacularly exciting and tense. Arthur Shaskelson presided, and presided then and for the next 7 years. His court shaped the foundation of our constitutional jurisprudence, for which I think we'll always be eternally grateful.
What must it have felt like to be in Makwanyane and Mchunu's shoes?
They weren't sure whether it was going to be a good thing for them. They were quite anxious about it because up to that point there was a moratorium in place on all death penalties. So, and for as long as the moratorium lasted, they knew they were safe. They also knew that this case would bring finality one way or the other and weren't sure that it would be against the death penalty. So they were quite anxious about it and not sure that they wanted finality. But obviously when the judgment came, they were very relieved about it.
Why did Parliament not resolve the issue, and why did it go to the
court?
court?
That was very clear that they were too lame to do it. On this issue of the death penalty, there was the issue featured in the constitutional debates as to whether the Constitution should permit the death penalty or not. But the politicians were reluctant to take a stand because whatever that stand was going to be would be unpopular with a significant part of the population. So what they preferred to do was simply to build into the Constitution a right to life and the other rights that you have in the Bill of Rights, and to leave it to the Constitutional Court to determine whether the death penalty was compatible with it. But there was a specific decision not to legislate for or against the death penalty in the Constitution because it was a politically unpopular thing to do.
So there was a very strategic...
oh, very much so. The politicians were very happy to duck the issue and leave it to the Constitutional Court to address.
Judge Johann Kriegler was one of the Constitutional Court's very first justices and presided over the case together with his colleagues.
Judges are generally seen to be applying the law, not making the law. That's really the role of the legislature. But the nature of the Constitution seems a little different to very clear laws. You know, it's just not a mathematical equation. It's not a logical syllogism. It seems to be a value-infused document.
Yes, certainly.
And so with S versus Makwanyane, the question before the court was whether the death penalty was constitutional. Now,
the thing is, there was no mention about the death penalty in the Constitution, and I'd like to ask you why you think that was the case. And in addition to that, how does one then reason with this document that is the Constitution, that has these lofty rights, but very little, content written out?
In Makwanyane, we decided that in a case such as that, we were entitled to refer to the debates of the negotiating parties at the time that the interim constitution was drafted. And we should remember that Makwanyane was a decision on capital punishment in terms of the interim constitution. Nobody's seen fit to debate it under the final constitution. That has never been determined, although the outcome seems pretty clear. But technically it hasn't been. We referred to, I think, what's called travaux préparatoire in order to get the thinking of the people who did the interim constitution. We decided that in the special circumstances of the drafting of a constitution, that unusual step was permitted, and we did so. It was fairly plain that the drafters of the interim constitution deliberately ducked the issue of the desirability of capital punishment. I believe that the reasoning on both sides of all sides in the negotiations was that we think that we shouldn't have a capital punishment, but wow, the constituency back there would be very unhappy if we put our names to an abolitionist approach. And there were a number of instances where the negotiators resorted to what they called constructive ambiguity. And in the case of the death penalty, it was certainly constructive ambiguity.
Had one held a referendum on the issue, South Africa would have voted for the death penalty. But modern democracy does not rest on crude majoritarianism. Rather, it is based on principles and rights.
I do believe, whether it's egotism, whether it's training, whether it's a combination of both, I believe one gets a perverse satisfaction out of doing what you know is right, notwithstanding its unpopularity. I think it's part of the Judeo-Christian ethic that you've got to do it. Myself, it's certainly founded in my Calvinist roots. Et ruit caelum, let the heavens fall, the justice must be done. I think that's the oath of office you take as a judge. So in Makwanyane, I certainly didn't feel any of that hubris, if you like, because it was a collegial judgment. We all agreed. I wasn't carrying the banner alone, sort of thing. And I think it was a rational, reasoned approach. And I do believe that if I'm talking to lawyers, one must not look so much at the so-called abolition of capital punishment as crucial in Makwanyane. The other stuff that Arthur dealt with, or articulated, that had been debated and was spoken on behalf of all of us, are even more important. The whole way of how you approach the balance between the limitation clause and the stark provisions in the Bill of Rights. How you approach that exercise, what do you do about it? How do you react? How do you react, if at all, to overt public opinion, which may also be political opinion or political pressure? I think what Arthur said there was crucial. The whole approach to constitutional adjudication put under the Bill of Rights in Makwanyane, I think was exemplary for many courts, not only in this country but abroad.
Out of all the arguments against the death penalty dealt with in this case, Johann is unequivocal on which he thought was the strongest.
Section 9 of the interim constitution said quite bluntly and in so many words that everybody has the right to life. Full stop. Unlike constitutions elsewhere to which we were referred in argument, where capital punishment is reserved, you do have protection of the right to life, but at the same time there is a reservation for the state to exercise the right to deprive one of that right in given circumstances. Our constitution said nothing. It just said bluntly, everyone has the right to life. I thought, and I think most of my colleagues thought, if I remember correctly, that it was a pregnant silence. And that it was left to us to bear the brunt of public criticism for the abolition, in quotation marks, of the death penalty. They didn't want, politically couldn't do it. It was a major policy decision in light of enlightened jurisprudence in many parts of the world. Capital punishment had fallen into disrepute. It had, in fact, fallen into disrepute in this country. And at the time when we were debating the matter in Makwanyane, there were some 400 people sitting on death row because the nationalist government had suspended capital punishment de facto, I think in 1989 already. So there was a backlog of 5 or 6 or 7 years sitting on death row, which created a major problem after Makwanyane, an administrative and technical problem. But clearly the Clark government did not want to do what enlightened thinking dictated. Clearly the ANC negotiators didn't want to do it. They passed the buck. I understood it that way. If you say that you have the right to life and you say no more, Pelelindaba, that's the end of news. Or as a police commissioner once said, finish and clear. That's it. And I think that although we all agreed with Arthur's reasoning and his beautifully articulated reasoning, the majority of those of us who concurred inter alia expressly because the Constitution said in an unqualified fashion, you have the right to life. Full stop. And Albie and I were probably the two opposite poles in ideology. And we both founded our concurrences on the right to life as articulated in the Constitution.
The South African Constitution contains a limitation clause. This clause enables the limiting of rights contained in the Bill of Rights. It states that these rights may be limited only in terms of law of general application, to the extent that the limitation is reasonable and justifiable in an open and democratic society based on human dignity, equality, and freedom. It then lists a variety of factors that must be taken into account when considering whether and how one might be justified in limiting a foundational right. The Bill of Rights is subject to the limitation clause in the Constitution. Now, although the right itself is very clearly laid out, could there not have been a case made for, the right to life to be forfeited?
Von Leres and Wilkow, on behalf of the Attorney General of Gauteng, of the PWD, I think it was, PWV, Southern Gauteng as it was in those days, Southern Transvaal, argued very forcefully with a great deal of material that he produced that the death penalty was necessary because it was the ultimate deterrent, and it had, therefore, in a country such as ours, with a history of violence, it had to be preserved, notwithstanding the clear language of Section 9. Von Leres was considered, and I grappled with it very much. Ultimately, the evidence considered by the U.S. Supreme Court in Furman versus Georgia and everything since then, a lot of material from Canada, from the United States, from the UK, I think there was some from the continent, ultimately could not establish that capital punishment was in fact a more powerful deterrent than a very heavy sentence of imprisonment. I am not sure, I wasn't then and I'm still not sure, that you could ever have absolutely dispositive evidence either way. It will ultimately have to be a weighing up of the evidence. But I did weigh the evidence, and I came to the conclusion that the disadvantages of capital punishment, quite apart from the breach of Section 9 of the Constitution, just did, and the lack of compelling evidence that there was really a difference in the deterrent force of the one versus any other sentence. One couldn't say that there was a justification in the kind of country that the Constitution contemplated we would hope to become, could still have capital punishment.
Tell us about the arguments that you used to persuade the court.
There were a range of arguments. One of them, which as a matter of law made a big difference, is that there is a consensus internationally that it's never been shown that the death penalty is more effective in preventing crime than any other penalty. And even the supporters of the death penalty internationally concede that that is so. What prevents crime is detection, prosecution, and punishment. But whether that punishment is then life imprisonment or a death penalty has not been shown to make any difference at all. And once you accept that it's not been shown that the death penalty is more effective in deterring crime, then there is no justification to take life, because it does involve taking a life. And I think that argument, one could feel, made a big difference. We have a right to life under the Constitution. The question is, what right does the state have to take a life? Well, if it would deter crime more effectively than any other available means, then you have the arguments for a justification of a death penalty. But when you can't show that it does so more effectively than other means of deterrence, then that justification falls away.
Looking at arguments for the death penalty, the deterrence argument is not a very strong one, as Johann and Wim point out. The retribution argument is far more interesting. If a person has committed a heinous crime, do they not deserve to die? Judge Yvonne Mokgoro, another one of the Constitutional Court's very first justices, presided over the Makwanyane case together with Johann. Yvonne explains that the argument for retribution must fail.
When the mothers and fathers of our Constitution negotiated the values and the issues around the Constitution, they did have in mind the notion that this is an African country in Africa, and that is why they borrowed from the idea of forgiveness in the context of Ubuntu instead of revenge. And that is central to the idea of Ubuntu. That is central to the idea of African humanity and African understanding of humanity, African understanding of the need to value the lives of others as you do your own life. And the value of the interconnectedness of human beings, no matter what their backgrounds, where they connect at the level of the humanity of a human being. I look at you, I look you right in the eye, I see you as a human being, and everything else is just baggage.
What about an argument based on retribution?
You know, I think that retribution is the only legitimate argument in favor of the death penalty. I don't think it should win the argument, but I acknowledge that the need for society, and particularly for the next of kin of the victims, to exact retribution is a legitimate one, and one that society should respond to. The question is whether retribution has to be the death of the perpetrator. I can understand that victims often feel that anything short of death is not good enough, but the measure of retribution should not be the emotion, the understandable emotions of the victims of the crime. Society has to play a moderating role in determining the proper outcome. And there is a countervailing consideration, which for me, at both a moral and a legal perspective, weighs more heavily than any other consideration. And that is that there are certain things which are which we as a moral society simply do not do, whether or not they bring effective retribution or deter. For instance, we don't gouge out people's eyes. We don't chop off their hands. Why do we not do it? We don't even ask ourselves whether it would be an effective deterrent or make for better retribution, because there are certain things which are just so abhorrent that it is demeaning of ourselves to inflict that on others. It's got nothing to do with the question whether they deserve the punishment or not. I often feel that people do deserve the death penalty, but I think it's demeaning of ourselves to employ certain means of punishment. I think the death penalty is one. Burning people on the stake is another one. Gouging out their eyes or chopping off their hands are other examples. Things that we simply do not do because it falls below a minimum level of decency decency and too shallow a word, humanity that we seek to uphold. But retribution is the one legitimate argument the other way.
What's up with the death penalty in the USA?
In some states where they have the death penalty, they invite the next of kin to attend the execution. Now, that's the retribution debate gone mad. But can you imagine, and I'm sure they have different values, they judge things differently, and I'll leave it to them. But I just find it completely macabre that the state should organize a state killing, a cold-blooded state killing, and then invite interested parties to come and watch for the satisfaction of seeing it. Another bit of evidence that we used in the death penalty case was a description by Dr. Chris Barnard of the biological impact of a hanging, of how the body reacts to a hanging. And it's the most gruesome description. I can't remember all of the bodily functions, but there are lots of sort of responses of the body to this mechanical killing, which are so abhorrent that if nothing else persuaded you that this was an inhumane exercise, that description does. To ask, does he deserve to die, is to ask the wrong question. The question is, should we engage in cold-blooded killing? Should we let our officials do it on our behalf? I think that if you want to have an execution, you should do it in public. It's far too sanitized to have those killings in private. If you're going to have them in public, so that the public can see what is being done in their name. I suspect that there will be crowds gathered for the entertainment value of it, but at least then people will know what is being done in their name. The way we executed people was a very sanitized execution behind the scenes. I had one client, one person for whom I acted when I was a junior advocate. We were all obliged to do pro deo cases. They were paid, I think it was 19 rands a day, to defend people at risk of the death penalty. And I did many of those. And in one of them, a death penalty was imposed. And let me say, if ever somebody deserved the death penalty, that was it. It was a young man of 21 or something, who together with his friends planned to rob his employer. I knew that the employer was a builder. He would come to the building site with a payroll on Friday, and they planned in their hostel, told everybody around them that they were going to hold up, they got a pistol, they were going to hold up the builder, and if he didn't hand over the payroll, they were going to kill him. And that happened. They held him up, said, give the payroll. He resisted, and they shot him dead. So it was cold-blooded, premeditated murder for financial gain. And if ever you had the death penalty, that would be a case deserving of it. But because I lit the case over 2 or 3 weeks or something, I got to know the accused quite well. And you ultimately learn that he is actually a pathetic human being rather than an evil murderer. Sure, he committed cold-blooded murder, and I wasn't sorry for him. But my overwhelming feeling was that he was not driven by evil. He was actually quite an inadequate and pathetic human being. And the idea that our society, our officials, will take this rather sorry human being and put him onto a scaffold and put a rope around his neck and kill him, I just found completely mind-blowing.
Retribution, I'm not prepared to argue. I do not live in a society, and I don't think our Constitution sought to create a society in which retribution could ever be the rationale for any kind of penalty imposed on anybody.
Gilbert was more open to discussing the retribution argument.
Gilbert, if we do a thought experiment and we take away the issue of resources and we have a situation in which we have perfect knowledge of a perfectly evil criminal who has committed multiple rapes and murders and what have you, and has shown no remorse and has pleaded guilty, and there's just no doubt about his guilt. In that world, or in that thought experiment, is there a role for the death penalty?
Well, you articulate the hardest case. In fact, you could add, if you really wanted to put a nasty question to me, you could add one further element. It's the person that you've described who, in addition to having done everything that you've described, commits a murder in prison.
Yes,
yeah. You can't get worse than that.
Here's the hardest case.
So I suppose it really then depends upon your attitude to dignity and cruelty. Is this a form of cruel, degrading, or inhuman punishment? Is it a violation of dignity? Because at the end of the day, it requires a human intervention to take that life. And one can have debates about the relative humaneness of different forms of the death penalty. In America, you've got a range of options. You've got the electric chair. I think the state of Utah still has firing squad. You've got lethal injection. In South Africa, you had the noose. At the end of the day, it's an ugly process, whichever way you look at it. And I think that there is a sense of dehumanization when, in a deliberate, calculated way, you go about extinguishing the life of a human being. And I think that's just the way I think I would see it. This was the first case. Our team had nothing to guide us in terms of procedure. We didn't know what tests the Constitutional Court was going to apply. We didn't know what their attitude was going to be to evidence. I had kept an article from many years ago, which had been written by the heart surgeon Chris Barnard, describing the physiological effects of what happens to a person who is hanged. We simply put that in, and it's reproduced, I think, in Cato Regan's judgment. We got hold of a book about the death penalty around the world published by Amnesty International. We just handed out copies to the court.
Our prisons are infamous for their poor conditions. Some are so bad that it has been suggested the death penalty may be less cruel.
The solution is then to reform the prisons, not to abolish imprisonment. And this point, and I get so upset when there's a public outcry for the death penalty because crime is overwhelming us. And the problem is it also serves the politicians' interest to blame the Constitution for the rampant crime problem that we have. But if you look at our levels of successful detection, prosecution, and imprisonment, Ron Paschke did some stats a while ago, some years ago, which showed that the crimes most successfully detected, prosecuted, and punished were, I think, murder and rape. But even there, the conviction rate is something like 12% or something. So that my feeling is that if you want to fight crime, the first way of doing, the most obvious way of doing it, is to jack up your crime-fighting capacity to catch the criminal, to prosecute them successfully, and then to punish them. If your conviction levels come up to 70, 80, 90%, and you still have a problem, well, let's talk about the death penalty then. But until you get there, don't talk to me about death penalty if you can't even get a conviction. You can't start killing people only because you're unable to catch the criminals. Anyway, I get too excited about it.
A common argument against the death penalty is that it is subject to arbitrariness.
I was actually a serving judge in trial courts where I had to exercise those powers in the Criminal Procedure Act. I did not have difficulty with them. In my career, I sentenced 2 people to death. I have no hesitation in saying that in terms of the law as it was, they thoroughly deserved to be executed. They were cases of the very kind that is contemplated by the legislation as it was. And there were umpteen cases of murder and or rape and or robbery with aggravating circumstances where the death penalty was theoretically competent that had never ever entered the picture. I knew my job. I wasn't an idiot. I had been in practice for a quarter of a century. I knew my people. I knew my law. I was confident in myself. And if I made a mistake, there were 5 people in Bloemfontein better qualified than me, and besides which there were a dozen people in the president's office who would deal with any death penalty case. The capriciousness, the arbitrariness under the law as it was, I don't buy that argument. I'm sorry, I'm far too arrogant to do that.
The unpalatable reality is that mistakes are made very frequently. Well, perhaps I shouldn't exaggerate. From time to time, those mistakes are only uncovered when it's too late. And that's the problem with the irremediability of the death sentence, is that it is final and there is no room for error. Now, I think that the universal experience around the world which has had the death sentence is that innocent people have been sentenced to death. And I don't know that one can ever escape that. I think that to try and escape that postulates some sort of perfect world which simply doesn't exist. And it's not enough, in my opinion, simply to say that the appeal court will put it right. Many of those cases never reached the appeal court. And it's also not enough to say we didn't have the Southern jury problem. Up until 1994, we had a virtually pure white male judiciary, most of whom were brought up under apartheid and would have gone to segregated schools and universities and would have wittingly or unwittingly absorbed the attitudes, or some of the attitudes, that prevailed at the time. And the simple truth of the matter is that the vast majority of those on trial for sentences, for crimes which would carry the death people, were black people. Their trials took place through interpreters. Their trials took place represented by the most junior members of the bar on a pro deo basis. That is simply flirting with the very distinct possibilities of miscarriages of justice.
Were innocent people sentenced to death in South Africa?
We certainly know of sentences of death that were imposed on people subsequently found to have been innocent. And I don't mean acquitted because there was a reasonable risk of. There was a well-known example, which we cited in our argument, of a man who was prosecuted for murder here in Johannesburg, was convicted on the strength of a confession taken by the Hillbrow murder and robbery squad, but was later found to have been in jail at the time of the murder. So it was proved beyond any doubt that it couldn't have been him. And so I have no doubt that there were cases where people were actually executed despite their innocence. And that's another important consideration. With all other forms of sentence, you can never undo the sentence, but you can at least go some way to putting right past mistakes. Once the accused is executed, there's no room for correcting mistakes, and mistakes do occur in any system.
Johann had expressed confidence in the old legal system in the sense that he did not think innocent people were put to death.
No, I don't share his optimism on that score at all. I think he probably holds that view because he was such a smart and meticulous a judge, but lots of other people weren't. And remember, the stock death penalty case in the 70s and 80s was a case of black-on-black murder, sometimes not particularly thoroughly investigated, that come before ordinary judges, not the Krieglers of this world, and is then had in a language which the judge doesn't understand, and is translated by an interpreter who is sometimes rather inefficient. So you often get a flawed interpretation of the evidence presented in a poorly investigated case. And the fact that errors occurred there, I think, was inevitable. I don't, apart from the one example that I mentioned to you about the conviction on the basis of a confession, I have no doubt that those errors occurred. We even have errors being shown up in the most sophisticated of first world societies these days, in the UK and the US. Our system then was pretty much far less sophisticated than theirs is today. So the fact that errors occurred and people were executed is no doubt. There was actually the testimony of a missionary who tended, I forget his name, he later had a son at the Pretoria Barn. I'm not trying to think of his name. But a missionary who spoke of a particular man and said how he, as this missionary, tended to people in death row, and how there was this particular man of whom because of that experience, he was able to judge, could assess in the final days before a man is executed, whether they were truly innocent or not. And he wrote of a very moving story of a man whom he had come to believe was truly innocent, and yet was executed. Now again, he might have been mistaken, but I have no doubt that mistakes of that kind were made. The question one should rather ask, if you were in favor of the death penalty, you might argue that mistakes are inevitable in any system, and we should be prepared to run the risk of a rare mistake from time to time. I can't for a moment subscribe to that approach, but that is the one has to adopt if you advocate the death penalty.
Other than the right to life, did Johann consider any other factors to be particularly weighty when deciding the case?
You know, the second rationale that appealed to me at the time, but it wasn't necessary for me to go into any of the others. But the second and most attractive to me was the irreversibility, the possibility of a mistake, and the inherent discrimination because of the discrepancy in capacity to put up a proper defense. It's theoretically strong. And I practiced in days when I was pro deo counsel as a ranked junior, and I practiced as senior counsel, and I practiced as a judge where I had inexperienced youngsters before me. But we were never, ever anything like a Georgia jury. We made mistakes, certainly, and I had colleagues on the bench who certainly I would not have liked to appear before. But I don't know that any of their horrible mistakes didn't get corrected in Bloemfontein. But the possibility of error and the discriminatory nature of it, the discrimination against people who cannot afford top counsel or top experts, certainly would have been, if necessary, a fallback reason for me to say that you can't justify the finality of capital punishment. But I didn't have to go there. I don't think you get convicted properly in our law, properly, unless it is damn sure you are guilty. And let's not be simplistic about it. The ordinary lay view of a reasonable doubt, they base on television shows of who is the serial killer, who raped this girl and left her body in a shallow grave. The overwhelming majority of criminal cases, the identity of the perpetrator is perfectly clear. The issue is a much more subtle one about how it came about and why it came about. A reasonable doubt on that? How do you do that? On his thinking at the time, his motivation. I find it difficult to conceive of a more stringent test than the one you have. And I think the one you have is the one that I applied in any event.
What was it like when someone was sentenced to death?
When you had to sentence somebody to death, it was a frightening prospect. It was a horrible prospect. I don't know if I could, if I think again, I would get goosebumps again at the atmosphere that developed in the court when somewhere towards the end of argument, it became apparent that this was one of those rare cases where there would actually be a death sentence. And you would see the deputy sheriff himself would come into court because in terms of the law, he's got to take possession of the accused there in court and take him himself to death row in Pretoria. And you saw the judge's clerk reaching in the other box for that black-framed form that has to be filled in, instead of the ordinary one where it says 15 years for suspended, where a chill descended on everybody. I never got over that as a judge. I think if you do get over it, it's time you retire. But thank heavens it's never going to happen again.
What was the weightiest argument against the death penalty, according to Gilbert?
You know, that's a very interesting question. One of the themes that Wim punted, which found a resonance with the court, and it was a phrase which he deliberately used over and over again, was that death is different. So it's a sentence which is irremediable. And I think that the argument which probably carried the most weight at the end of the day, was that its implementation was arbitrary. It depended on how well resourced the accused was. It depended on their ability to afford a lawyer or not afford a lawyer, as the case may be. It depended upon their race, and it depended fundamentally on the attitude of the presiding judge to the death sentence. Because we were able to show by surveys done in South Africa that there were very dramatically differing views by judges when it came to the death sentence. There were some who were vehemently opposed to the death sentence, and there were those who thought that it was the solution to serious crime and didn't flinch in passing the death sentence. So it would have been blindness in the extreme to ignore the fact that your chances of being hanged depended upon the judge before whom you appeared.
A substantial amount of the judgment is about the fact that the death penalty is cruel and unusual punishment. Is this something that had any argumentative weight?
I didn't buy it then, I still don't buy it. I've seen people die much more cruelly than being executed. I haven't seen people being executed. I've been on death row, I've had a look there, but I've got a much greater objection to the execution process than the cruel, unusual punishment part of it. I think it degrades society itself to kill when it says thou shalt not kill, and to coldly and deliberately, through its agencies at the most lowest possible level, putting to death a person in cold blood, to me is anathema, yes, but not from his point of view, from my point of view, from science society's point of view. I don't want to live in a society where we act like that, and I don't think that's what the Constitution contemplates. The society that enjoys this attracts onlookers to come and look at this. The people who stop at a motor collision to see, there isn't any blood, let's drive on. It's that kind of public sentiment that the law must set its face against. And I think the capital punishment is the ultimate example of kowtowing to the most atavistic, most primitive bloodlust that all of us probably have somewhere in our limbic brains anyway. We hope to keep suppressed.
Are there more demeaning ways of dying? Yes, I'm sure there are. But is the cold-blooded execution of a human being something that we should officially do? No, hell. The question is not whether there are worse ways of dying. The question is whether we as a society should in cold blood take a person onto a scaffold and put a rope around his neck and kill him off. I just don't think that that's compatible with any of the values that we subscribe to under our Constitution. So the question is not whether there are worse ways of dying. The question is whether it is permissible for society on your behalf and on my behalf to commit that cold-blooded killing, and I don't think it is.
I don't know whether I would have regarded myself as an evangelist opposed to the death penalty before the case. I certainly was opposed to the death penalty, but I wasn't one of those who stood up on public platforms proclaiming my opposition to the death penalty. But what I can say is that having prepared for the case, I was absolutely convinced that it was not simply unconstitutional, but that it was utterly inappropriate in a democratic order.
The systematic, conscious, deliberate killing of a human being is, for me, the crux of the inhumanity of the death penalty. Our Constitution gives us so many other bases for seeing it as a system of law which has no place in a democratic society which values human dignity, freedom.
Thank you for listening. I'm Cecelia Koch, and this was an episode of Landmark Judgements, a show about South Africa's major constitutional court cases. This series is brought to you by the Friedrich Naumann Foundation for Freedom.